Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be discussing the upcoming sentencing hearing of Derek Chauvin, the plea bargaining process in the federal Capitol riot prosecutions, and the story of a former drug dealer who's now been sworn into the Michigan bar by the same judge who sentenced him on drug dealing charges 16 years ago. In segment two, as promised, we'll be exploring the research into false allegations of sexual assault. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. Erica, it's good to see you this week. Did you see in the news that Derek Chauvin has asked for probation from the judge in his murder sentencing hearing as prosecutors seek a 30-year prison term coming into his sentencing hearing?
Wow, is that even possible to get probation when you've had a murder conviction? That sounds like it's impossible.
So in Ohio, there are mandatory sentencing laws for things like murder and a variety of other crimes. In Minnesota, this news is so fresh. We haven't had the opportunity to research the Minnesota sentencing laws in this depth, but there are the possibility on a variety of offenses for a defendant to make an argument at sentencing for a judge to use discretion and deviate from the guidelines. Now, if the guideline is mandatory, however, the court does not have that discretion and must impose a penalty that was determined by the state legislature. This news is so fresh. We haven't had the opportunity to look at it yet, but we're going to be looking into it and we'll update you on that question next week.
Wow, that's amazing. I can't even believe that that's a possibility. And so I know that judges really, they work on what's right. They look at the law, and in some cases they're really looking at, finding out what the recommendations are from each side and coming up with some kind of compromise. How will a judge make this decision when the two sides are so far apart on their recommendations?
In Ohio, judges are guided by the purposes and principles of sentencing, the seriousness and recidivism factors, and in certain situations, the requests of the victim. Now, in Minnesota, the judge is guided by, okay. 3, 2, 1. Likewise, in Minnesota, the judge is guided by statute, and the law requires the judge make specific findings of fact that support any decision as to what the statute requires.
So why are aggravating factors decided by a judge and not a jury? You would think that they'd all have to sit down and decide on this when they're deciding whether to convict or not.
Aggravating factors in Ohio, or what we know as the seriousness factors, are decided after conviction for a variety of reasons. First, they require a conviction in order to be assessed under the statutory and case law framework. Additionally, they don't enhance the penalties that were already set by the legislature. Rather, they act as a guide for the judge to select a penalty within a predefined range. Now, this contrasts with a variety of states, for instance, Texas, that allow juries to make recommendations for penalties following a conviction. Now, prior to a conviction, a defendant is presumed innocent, and therefore there's no possible consideration of the facts of the case to be used against or for the defendant. The state and the defense argue those statutory factors at a sentencing hearing and through written arguments before a sentencing hearing. But ultimately, the court makes the final determination as to what the sentence will be.
That's really good to know. And I can't wait to see what happens with this. I hope that you'll keep us apprised of the situation once they decide.
We're going to absolutely keep everybody up to date on this process. I think the sentencing and the progress of the Derek Chauvin case is probably the hottest topic in the criminal injustice system right now. And we're going to stay on top of this story and make sure that our listeners are well informed about what's going on. In other hot topics in the criminal injustice system, Erica, did you see that a Capitol rioter has cut a plea deal? And do you know what that means for the other Capitol rioters?
Well, you know what? I have to admit that I've only really heard plea deals and that sort of thing, like in the movies. And usually it's when they're trying to get an innocent person to admit they're guilty. And that's the story plot. I don't know if that's what's happening here. How does one plea bargain outcome influence hundreds of other charged cases, in this case of the Capitol rioting?
So the terms of the bargain are going to give all others considering a bargain insight into the position of the government, the arguments that they're going to make at sentencing. And regardless of whether it's on this charge or a different charge, it's going to provide a framework, a foundation, if you will, for what these cases are going to be argued over when it comes to sentencing. The terms of the bargain will also reveal the government's position on specific aggravating factors and how they want courts to interpret an individual defendant's alleged prior criminal history as it applies to this specific circumstance. Remember, we've never had since the Civil War an insurrection inside the United States. So this is really unique in the history of the federal criminal justice system. It's not just the pled to charge that defendants in the federal courts have to be careful of, but also how the government intends to portray all the surrounding facts and circumstances, including the defendant's prior criminal history, to the judge at sentencing. That really controls what the ultimate outcome of the case will be.
Wow. I mean, this kind of reminds me of, when I do something wrong when I was a kid, and my mom would say, just admit it and you can have a cookie. And so I just am wondering if it's the same kind of situation with the judge where, they'll give you some credit, they'll give the accused credit for entering a guilty plea.
They absolutely do, Erica. Federal prosecutors can recommend judges accept downward deviations and reductions in sentencing guideline ranges for people that enter guilty pleas and people that enter guilty pleas quickly. So it's not just that you admit what you did wrong, but you got to admit it fast in the federal system. That's the reason a lot of federal defendants go straight from arrest and almost skip the formal indictment and litigation process and go straight to pleas and sentencing. This is one of the elements of the plea bargain that a defendant in the federal system has to be looking for and fighting for, because those 2 and 1 additional point downward departures or guideline range reductions is so significant. And you're talking about the reduction of years off of a sentence. The court can also credit a defendant in the federal system for his or her remorse and any other mitigating circumstances that the judge deems appropriate under the sentencing factors. So there's a lot of opportunity in the federal system to kind of fall on the sword, admit you were wrong, and beg the mercy of court. And really, that is one of the best ways to get sentencing reductions in the federal system.
Wow. I mean, I guess it's great that your clients have you, because I can't imagine trying to navigate plea bargaining and trying to figure out what's fair and what's not fair, because you do hear about a lot of problems when it comes to plea bargaining as far as like admitting to something you didn't do. But I guess if you did do it, you might as well get the credit for it and get your sentence reduced. So is the federal court required to accept a joint recommendation for a sentence?
No, federal court is not required to accept a joint recommendation and may modify or even reject any plea bargain it sees fit. This is pretty common across all levels of the judiciary, both federal and state. Now, whether that's a likely outcome is highly dependent on the individual circumstances of each case, and federal judges reject plea bargains altogether if they don't agree with the proposed resolution. They either find it to be unfair to the people, or the notions of society, or they find it unfair to the defendant. They can reject a plea bargain for any of those reasons. This is another reason to be careful in the federal plea bargaining process, because the bargain may require a defendant to waive his appellate rights to a sentence that's been received, unless it's outside of a guidelines range, which may not be the case where the court rejects a joint recommendation.
Wow. Well, I can't wait to hear what happens. This is one of the most interesting cases we've seen. Like you said, there hasn't been an insurrection for a long time in the United States. And certainly they probably weren't talking about plea bargaining back then.
Well, yeah, and the reality of the Civil War is that many of the leaders of the rebels in that case were never prosecuted. Some were, but the vast majority of people who revolted against the United States of America were never faced any consequences for that. They were just sent home. The Capitol rioters, again, the vast majority of them are never going to be prosecuted. But those that are dealing with a much more robust federal prosecutorial system, and I think they're going to face some pretty significant consequences as the result of their conduct. Now, somebody that faced the consequences and has come back stronger than ever, I think our good news story of the week this week is Edward Martell, who has now been sworn into the Michigan bar after being convicted as a drug trafficker 16 years ago.
What an amazing story. And honestly, they should probably make a movie about this, because it sounds just like one of those stories where somebody just overcomes what you think no one could overcome. Most people probably would have a horrible life after starting off with the way Mr. Martel started off. So can you fill us in on how did Mr. Martel come to be in front of the judge on drug trafficking charges?
So Edward Martell grew up in poverty, and as a result, he fell into drug trafficking to meet his basic needs. His first conviction was at 13, and by 15 years old, he had dropped out of high school and left home. Mr. Martell appeared before Judge Morrow, and the two formed a connection that changed Edward Martell's life, with the judge supporting him through high school, college, law school, and ultimately admission to the Michigan bar.
Well, I mean, that's just such a wonderful story. I'm wondering if this could happen again. I mean, what is the process like for people who may have convictions, but they want to be lawyers? I mean, it must be, they must be amazing lawyers, having come up from being a convicted criminal themselves and being able to make good. They must have a lot of great advice for their clients.
Absolutely, Erica. The insight that somebody that has been through the system can bring to the table is invaluable. You'll remember from my past, when I was a juvenile, I was falsely accused, and while I've not been through the entire process in the adult criminal system, going through the delinquency process, through a bench trial, being found not responsible, having the case dismissed against me, was one of the catalysts that propelled me to where I am today. And it certainly helps me relate to my clients. I understand the stress that they're under. I understand the fear of getting on the witness stand, because I got on the witness stand. I testified in my own defense. So having that experience, having been through it personally, I think Mr. Martell is going to bring a whole new level of understanding to his clients' cases.
Yeah, that's amazing. I'm really excited to hear about this new lawyer and see what he does. I'm sure there's going to be some interesting stories coming forth of his success. So why is it important that people who may have prior convictions be allowed to qualify for bar admission and ultimately to practice law?
It's critical for representation in the bar for from people who are convicted and have been shown to be rehabilitated. They bring a unique perspective. And the thing is that the law is a self-regulating profession. It relies on other lawyers to report their own misdeeds, but it also relies on lawyers to be honest about reporting their own mistakes. And the first test of that is the character and fitness examination process. It's important to show both people in the legal community and people outside of the legal community that if you submit to that process and you rehabilitate yourself, you're going to be given that second chance. And certainly as well, Erica, it's important that those who have experienced the criminal justice system be allowed to participate in it because of their unique perspective.
I mean, it sounds amazing, and it makes a lot of sense. And I know that lawyers are held at a higher standard. They're expected to follow the rules, but they're also expected to be honest if they do make mistakes. And I think that, unlike most professions, they really do police themselves and hold themselves to that higher standard. So, Brian, can you tell us, what's the process like for people who may have convictions who want to be lawyers?
Well, the path is the same as any other lawyer. You've got to graduate from high school. You have to obtain a bachelor's degree. You have to graduate from law school, earning your Juris Doctorate, and then you have to take and pass the state bar examination. Where it becomes different and maybe more difficult for somebody that's got a criminal conviction is the character and fitness examination process. Now, every lawyer in the country has to go through this process, and they submit their entire background to their county bar examination and the National Conference of Bar Examiners, who conduct a detailed, in-depth background check. And that background check is then sent back to the county bar examination, the County Bar Association, and County Bar Association attorneys then bring those candidates in and basically interrogate them on every bad thing they've ever done. I personally went through an interrogation about the false allegations that were made against me. I've heard of lawyers having, just being raked over the coals over getting, 4 and 5 speeding tickets between the ages of 16 and 25, academic failures, low grades, anything that, that bar committee can examine them on and question them on, they do. And the candidate has to disclose all of this and have good explanations for why those aren't moral failures that should keep them from becoming an attorney. The bar admission can also consider, however, letters of recommendation and support, as well as other relevant documents to consider a particular situation and the total rehabilitation of the candidate. So it's not just going in there and getting grilled, but it's presenting an entire package, very similar to how we approach sentencing hearings in criminal court.
That's really good to know. And I'm glad that Mr. Martell passed and we're going to be able to follow his career.
Absolutely. And Erica, with that, let's transition into segment 2 today. In the wake of the Me Too movement and the controversy surrounding the confirmation of Supreme Court Justice Brett Kavanaugh, there are competing principles that have emerged. On the one hand, an intention to believe the victim, and on the other, the preservation of an accused person's presumption of innocence. So studies on the prevalence of false allegations seem to indicate that anywhere from 1.5 all the way up to 90% of sexual assault allegations are outright lies. So how does research inform the defense strategy in a sexual assault allegation?
I just think that that's shocking. I don't even know how it's possible that there would be such a huge range. Can you give us a little insight to that? I mean, 1.5% to 90%, that's like just like toss the dice or flip a coin. I'm not sure why there's a range like that.
Well, in this particular area, Erica, I think the range is dependent on a lot of factors, not the least of which is that this is a highly politicized area of psychological research. Now, scientific research shouldn't be dependent on politics. But if we go all the way back to the 1980s, where we had the demonic possession, Satan worshiping scares, we move forward into the 90s to the child rape hysteria, moving into the 2000s and the 20 teens with the sexual assault prevalence and fear mongering, and now the Me Too movement here in the 20 teens. There has always been pressure on the psychological community to believe accusers, believe children, believe women. And I think that has caused people that do research on this particular area to frame their results in a way that reaches the outcome that they kind of want. The results of any study really depends on those parameters of how the study is conducted. And in this particular area, studies may only count an allegation as false if it was affirmatively recanted by the accuser. Those are the studies that produce false allegation rates in the single digits. In other studies, an allegation can be considered false if there's no corroborating evidence like DNA, physical evidence, or a witness to support the allegation. These studies generally find the false allegation rate to be in the 20 to 40% area. And in some studies, an allegation is considered false if a defendant is acquitted, or if the report isn't made within a particular period of time, or if charges against a defendant are either dismissed or never issued. And in those situations, now our false allegation range is in the high double digits. Some of these studies only look at child accusations. Some studies only look at adult accusations. Some only look at situations involving alcohol, while others look at situations that only involve force. This is why it's critical to fully vet any particular study and paper, and if possible, work with an expert who is well-versed in reading and understanding these materials. Because time and time again, you'll see prosecutors try and shoehorn in these low-digit studies as some kind of evidence that people don't lie about sexual assault allegations, when the reality is the numbers can be as much as 90% of the time they're lying about these allegations.
Wow, that is amazing. And that's really a sad statistic, because that means people's lives are getting ruined forever because somebody decides to lie for revenge or for fear. There's a lot of different things that could go on, as to why somebody would do that, but the consequences for the falsely accused are just so high. So how can the research be used in the defense of an accusation?
Yeah, so investigation may reveal that the accuser has made prior false allegations of sexual assault. And in order to use that information at trial, what's called a rape shield motion and hearing have to be held so that the defense can present that evidence. And that's the perfect opportunity to use these studies as to why false allegations should be admitted at trial, because of the high prevalence. With the right motion work, an expert witness might be able to testify to the jury about the rates of false allegations from an academic perspective in order to inform them about the reality of false allegations, because a lot of people don't believe that false allegations are real. And in order for there to be testimony on the record that a jury can draw upon and conclude that this particular accuser is not being truthful, the research helps guide the defense investigation by providing a knowledge base of what records to look for, what circumstances frequently produce false allegations, and what information can be collected in order to support the defense claim of a false allegation. So there's really a variety of ways that these psychological studies can be used by the defense team.
I can see where having somebody that can navigate through the experts and really using this information to your advantage in order to get the best outcome in court. So I think it's so important to have an attorney when it comes to this. So can you tell us why is it important to research the topic of false allegations of a sexual assault?
I think this is so important as an area of research for the psychological community, because the tension between these competing principles of supporting real victims of sexual assault and preserving the presumption of innocence are so important. The consequences for any individual of, you know, being traumatized by a sexual assault or being traumatized by a false allegation of sexual assault are so significant, so life altering, that this particular area of psychology needs further investigation and well conducted studies. There need to be parameters set for how to run these studies and how to report the results. Research into all aspects of human sexual experiences is really necessary. And I think, especially in this day and age, as we become more open to our sexuality as humans, we need to inform the laws of our society so that we know what to prosecute, what to educate, and what to say, you know, this is a life experience. Especially as it comes to sexual misbehavior. You know, sex is so taboo. It's such a topic that people don't like talking about, people are uncomfortable talking about. But the reality is, when when sex is the topic, communication is the answer. And research provides guidance for educators, parents, and the legal system to both offer support services to the alleged victims as well as the accused.
That makes a lot of sense. And, honestly, I think there'd be a lot less false accusations if people were less embarrassed to communicate about sex.
You're absolutely right, Erica. We literally just finished a jury trial wherein, our client was ultimately acquitted. And my belief is the jury found him not guilty because of the lack of communication or the unclear communication between those two individuals. Maybe we'll take one of these episodes and do a deep dive into the anatomy of a criminal case in a future episode. But for now, I want to say thank you, Erica, and thank you to all of our listeners out there. It's important that you become informed about these developments, about these topics, and in order to stay on top of these topics and be informed about the biggest issues in the criminal injustice system, holding the government accountable for their misdeeds, false allegations, and everything you need to know about your constitutional and civil rights, check out the law office of brianjones.com. Look to our Facebook page, facebook.com/Central Ohio Criminal Defense, and at TLOBJ on Instagram, TikTok, and Twitter. We'll be back next week with a sui generis perspective on the next big thing in the criminal injustice system and civil rights news, as well as a discussion of those seriousness factors as it comes to sentencing in Ohio courts. Now, Erica, when my grandfather would part ways with me when I was a child, he would always tell me, "Hey kid, don't do anything I wouldn't do." And today, when I part ways with my friends, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.